Hello everyone, welcome back to my channel. I hope you all are doing great, and today we are back with yet another latest case of the Supreme Court of India. This case is relating to the Negotiable Instruments Act and it's a very interesting case. So let's begin with the video. The title of this case is TRL Krosaki Refactories Limited versus SMS Asia Private Limited. It was decided in the last month, as in February 2022, and this case was decided by a 3-judges bench of the Supreme Court of India consisting of Honorable Chief Justice of India N.V. Ramana, Honorable Justice A.S. Bopanna and Honorable Justice Hima Kohli. Before moving ahead with the case, let's see a little background of it, how this entire cause of action took place. The respondent of this present case, SMS Asia, had issued 7 checks, in total 7 checks amounting to 1 crore 10 lakhs rupees. And these checks were issued to TRL Refactories. The respondent of this present case, SMS Asia, they had issued total 7 checks, and these checks were amounting to a total of 1 crore 10 lakhs rupees, and these 7 checks were given to the appellant of this present case, TRL Refactories. As per the provisions of Negotiable Instruments Act 1881, the amount which is mentioned in a check, it will be paid to you only when you demand for it. As in, once you receive a check from someone within 3 months from the date which is mentioned in the check, you need to go to the bank, you need to deposit the check in the check drop box, or in case of bearer check, you need to present the check in the counter. That means you need to demand for the money, only then you will get the amount. Right? So in this case also same thing happened when the appellant company TRL Refactories got these 7 checks. What they did is they went to the bank and they presented this check to claim for the amount. But what happens when these checks were presented in the bank is that bank returns this check with a memo or with an endorsement. And what is this endorsement? That account closed. Whatever account was mentioned from which this 1 crore 10 lakhs rupees was supposed to be given, that account itself was closed by the respondent company. Now this honor of check may happen because of multiple reasons. Like in this one, account was closed. Maybe the person is not having sufficient funds in his bank account. Maybe he has not authorized the bank to issue that much of amount by way of check. Or maybe the signature is not matching. So there are a lot of reasons because of which a check may be dishonored. But when a check is dishonored, we cannot straight away go to the court and file a case. What we need to do is we need to give a demand notice to the person. As in, we would not straight away go to the court and file a case, because sometimes it might happen innocently also. The person was maybe not aware that he had given, like companies would issue so many checks, right? They might not be having a track of how much of amount they should be keeping in their account for all these checks to be cleared, right? So the person who is issuing the check, that person should be given an opportunity that if this had happened by mistake, he can still clear the amount without going to the court, without filing a case. Okay, so what we need to do, once the check is dishonored, we give a demand notice to the person and we give a reasonable time to that person that you need to make this clear, like you need to pay this amount within this certain date, otherwise I'm going to the court. In this case also, demand notice was given to SMS Asia Private Limited. But what they did is they ignored the demand notice. They did not clear the amount even after that. If your demand notice is not answered or if the amount is still not cleared, next option you have is going to the court and filing a case. For check bounce, cases are filed in magistrate court. If you read the Negotiable Instruments Act, magistrate court is the right court having jurisdiction to try these matters. So same thing happened here also. TRL refectories, they approached the magistrate court, subdivisional magistrate court, to file a case under section 138 Negotiable Instruments Act. When this case was filed before subdivisional magistrate court, they did mention the entire thing, what has happened, how this amount was due, how the checks were dishonored and everything. And based on that complaint received, magistrate took cognizance of the matter. As in, magistrate took notice of the matter and they took the further steps to proceed with the case. And what is the next step? Next step is to issue summons to the defendant, right? So same thing happened here also. Subdivisional magistrate issued summons to SMS Asia Private Limited to inform them that so and so case has been registered against you. You need to appear before the court on so and so date. Now, when the accused SMS Private Limited received the summons, they came to know that so and so case has been registered against them and they were not happy with this fact. They approached the High Court of Orissa under section 482 of CRPC and they said that the magistrate has taken cognizance of this matter, but the complaint which was filed, it was filed by General Manager Accounting of that company, whose name we had written in the check. As payee, we had written company's name, but case is filed by the General Manager Accounting. Plus, in their complaint, they have not specified how come the General Manager Accounting is getting power to file such a complaint. Whether General Manager is an authorized person also or not to file a complaint, bring an action in name of the company, that is also not clearly reflected in the complaint. So as such, General Manager is not a right person to file a case in this matter. He was not the payee in those checks, 7 checks which we have issued. So what happens is, magistrate should be restricted in proceeding with this case. And Orissa High Court also looked into the matter. They also saw the complaint and they concluded that yes, in the complaint, the company has not as such specified how, or is it actually the General Manager is having the power, is the General Manager authorized person to bring such a case or not. Orissa High Court passed an order in favor of SMS Asia Private Limited. Now what happens? TRL refectories were already not getting their amount. They wanted to recover that 1 crore 10 lakhs rupees. Their checks were dishonored. They filed the case. There was restrictions put by the High Court. They were not happy with this order that was passed by Orissa High Court. So what they did is, so they approached the Supreme Court of India by way of this case that we are discussing today. TRL Krosaki's Refectories Limited versus SMS Asia Private Limited. And when this case was filed before Supreme Court of India, Supreme Court said that under provisions of section 138 and 142 of Negotiable Instruments Act, when a case is filed before the court where payee was a company, as in company was the entity who should have received that amount, in such a case, company needs to be a party to the case necessarily. But someone needs to be there who would represent the company. And in such a case, General Manager Accounting, if he is representing the company, there is no problem as such. So Supreme Court of India had set aside the order that was passed by Orissa High Court, and Supreme Court gave a decision in favor of TRL Refectories, who was initially the victim in this particular case, whose amount was not cleared and check was dishonored by the bank. Actually, the General Manager Accounting was authorized. He was given the authority by the company, by the Board of Directors, to file such a case. So if a case is filed under section 138 and 142 of Negotiable Instruments Act and it is filed by an authorized employee representing the company, and it is mentioned in the complaint also, that is sufficient for the magistrate. As such, magistrate would not say that in the payee name company was mentioned, not yours name. That is not like a ground. So there is a valid reason for magistrate to take cognizance of such a matter, and magistrate can start with the proceeding as well. If payee was a company and case was filed by someone who is an authorized person representing the company. So that's about this case. It's a very interesting case relating to Negotiable Instruments Act. If you are preparing for Judiciary and Negotiable Instruments Act is part of your syllabus, do keep this case in mind. Do keep a note of this particular name also, because you need to prepare this case before your interviews or before your exams. Otherwise also, if you are preparing for CLAT or any other competitive exam, definitely latest legal happenings, latest decisions, these are very important for you to read. So that's all for today's video. I hope you found this video helpful, and we will meet again with another latest case of Supreme Court or maybe some other court. Until then, bye-bye.